engagement letters.
Okay, do you want me to talk, or you want?
Please.
Okay, so you have, do they have this? Okay, so you have the special education and student service legal engagements, and it shows you there was a total number of 9 legal engagements this year. Don't think that's the spirit of why you put this on there, but you have that.
Yep.
Special ed and student services had 5 legal consults, and to Mr. Boyle's point in the past, and then there's the day-to-day operations, things that I either have to do as an SAU superintendent, which is a different expectation, at Timberlane, or Hampstead. It could be any one of the 3. I kept this, responding to this typically just as a Timberlane employee, although I'm not a Timberlane employee, I'm an SAU employee, but the Timberlane version of this. That make sense? So
Sure.
the question could come in from one of 3 ways, and anything can go under the SAU umbrella, so to speak, or something might be very specific Timberlane or very specific Hampstead. So,
Okay.
yeah.
And I think I just wanted to make an agenda item just to clarify it, just so, which I think gives the board more rights as to who the client is. That's all. Should be the Timberlane School District.
If you want the letters, when you ask for a legal opinion, if you want the letters addressed to the Timberlane School Board, and they would go, typically when I get them, I would just forward the to you and probably to the vice chair. I always sent it to the chair. I think Kelly's
I
stepped
think
out.
generally send it to Kelly, too.
Yeah, I'd send it
Yeah.
to both of you, and then you can send it out to board or do whatever, but if if the address on it is important to you for whatever reason.
Well, it's not so much the address, it's the client.
I mean, the client, I'm not saying the address.
Well, the client is important,
Yeah, it's very
because
important.
if the board is not the client, then the board cannot make a decision as to whether or not to release a letter to the public.
Yeah,
That
I
is
know
an
that's the-
important, that is a very important point to make, is that we can't release a letter unless we are the client. If you're the client, we can't release the letter. If we're the client, we can. So that needs to be done. I'm not sure why, so this is a question. What would be a case where you would be the client and not the board? Or the board or the SAU? Why would the superintendent be the client for a lawyer as opposed to one of the 2 boards? It's just a question, just throwing it out there.
I mean, I don't have the answer.
I think-
Peter knows that one.
If the superintendent is named directly in the suit.
Suit.
Oh, sure, okay.
Oh, we're not talking that, though.
No, I'm not talking about that. I'm talking about just general,
Oh, okay. Sorry.
not a lawsuit. That's so.
Yeah, if it's just a general, if you're asking me to get a legal opinion, and I think they've always been addressed to the superintendent. I don't know, I mean, I don't know how far back they go, but.
Well, and correct me if I'm wrong, Brian, or the other board, but I think what I know I would like to see is that any legal opinions, especially as they relate to the board, are addressed to the board, and that the superintendent doesn't don't engage legal counsel to consult about board business. That would be up to the board to
Yeah.
engage legal counsel to discuss board business.
That's all. Yeah.
So if I call as a Timberlane, if I call on behalf of Timberlane, I'll make sure that it's addressed to the board, if they send us anything.
Correct.
Correct, but to also that you would not call about a school board issue unless it went through at
The
least
chair.
the chair of the school board.
Yeah, so obviously, when you're calling for a special ed thing or whatever happens on a day-to-day basis,
That doesn't have to go through the board.
that doesn't go through us.
Right, but if it's something that pertains to the board, it should go to the chair of the board
Yeah.
before action's taken. Does that make sense to everybody?
Yeah.
Is everybody in agreement?
I don't agree about special education being a day-to-day issue. We had 14 legal engagements in 16-17, and,
That's his responsibility.
but we should be deciding whether we want to pursue some of these in court, or, all of these should be coming to the board for a board decision. If we're,
I agree with that, but I'm just
yeah,
saying,
so
These
if,
are not court things, these are mediations.
These
This
aren't
is
courts.
this is the day-to-day operations, the work of the district. That's what it is.
well, I don't think it's a day-to-day thing to be dragged into a legal engagement because of special education. I mean, if that is, maybe that's something the board ought to be aware of. Because it said special education and student services had 5 legal consults on cases. We didn't know anything about any of those. How can we be a board and not know a single thing about any of those?
well, I would just, for future things, if you just let the board know just what's going on, that's all. To me, that's, my concern is to make sure that the board is involved in knowing what's going on. And then as Kim just, it's,
I can speak in generalities, but these are all privacy issues with students. These are all, it couldn't be in here, and then,
but that's, I think, that's what that's what we're asking for.
that's what you're asking, that's not what she's
Oh.
asking.
Okay, well, the board, as far as I'm concerned, the board should just be apprised when a legal situation comes up and something happens, a slip and fall in the parking lot, especially.
We can do that, but I mean, we
that-
can just call it legal updates.
Yeah, there you
I'll
go.
just give you
There you go.
ongoing legal updates.
Fantastic.
What Mrs. Green's asking for is something we can't do.
That's fine. Okay, so let's, I'd like to move on to, if you could give us your Surest update.
Sure, the Suresk update, they did, I think,